Hi there, welcome to BloombergQuint, and this is the fine print. There's a strange twist in the DHFL's insolvency case. This week, NCLT Mumbai asked the creditors committee to vote on DHFL promoters Kapil Vadva's settlement proposal. This even as more than 93% COC members by vote share have already approved Piramal Group's resolution plan for DHFL, and that has also received RBI's blessing. So, what prompted the NCLT to give such a decision? Has it muddied the waters for settlement process under IBC? And what's DHFL's surest way out of this mess? We'll put all these questions to our guests who are joining us this evening, Supreme Court Senior Advocate A.S. Chandhiok and Bombay High Court Advocate Amir Arsiwala. But before that, my colleague Vishwanath Nair joins us to bring us up to speed with the developments in the case so far. Vishwanath?
Thank you for that, Payaswini. Sort of saddle up because this is a long process that has happened. Of course, DHFL was brought into the IBC fold in November of 2019, and this was the first financial services case which underwent an insolvency proceeding at the time. Immediately after that, of course, there was expression of interest that was invited from multiple people. The committee of creditors got about 24 expressions of interest from various people. Those filtered down to actually 3 bidders. Now, what happened is over the course of the negotiations that took place between the bidders and the committee of creditors, Kapil Vadhavan started sending out letters to the COC saying that he can come and offer more money to them and settle all of their dues. Remember that this is all happening during the COVID-19 period, during which time, of course, a lot of delays have already taken place since people can't really meet and they can't really talk to each other. Over the course of October, November, and December, Kapil Vadhavan repeatedly reaches out to the COC. Finally, in December, he submits a letter which proposes to pay the entire 91,000 crore worth dues to the creditors, and it's structured in a certain way. And the creditors, of course, they have not really looked at the plan seriously. What has happened is that AZP Partners, which was the legal representative for the DHFL administrator, they looked at the resolution proposal and they wrote back to Kapil Vadhavan saying that this proposal is not admittable and they would be rejecting this. And of course, then Kapil Vadhavan goes to the NCLT. The NCLT finds some merit in his claim that his proposal should have been officially considered by the COC, and if they have not done that, then of course that process needs to happen. And then on May 19th, the NCLT passed this judgment, passed this order saying that the COC will have to look at this this proposal. They will have to review whatever is being proposed by Kapil Vadhavan and have to take a decision, and then of course vote on the plan. Of course, all of this is happening, over the course of multiple months. During the hearings that took place between Vadhavan, the COC, as well as the RBI, which has been put up as a respondent in this case, the COC argued that they did not believe that there is any merit in Vadhavan's proposal. On the other side, the RBI said that it had only pushed the letter that Vadhavan had said to the COC, and its job was over. The RBI did not want to get involved in the entire CRP process because they wanted that process to be an independent thing where the RBI is not interfering. Of course, all of this is taking place over the course of many months, and then finally the NCLT says that the COC has to look at this offer seriously. Back to you, Payaswini, for further details.
Sure. Thanks, Rishi, for this. And briefly, Vadhavan's case has been that he was not involved in or allowed to participate in the COC meetings, and the COC rejected his first settlement proposal, not on merits, but on his eligibility to submit a proposal. Funnily, he has also argued that his proposal is a precursor to the withdrawal process. So the COC rebuttal or COC's contention that his proposal must come with certain bank guarantees is not required because Section 12A is not yet triggered, because at this point is it just a precursor to the 12A process. NCLT has essentially looked at the difference in the value that, or the offer that Vadhavan is proposing versus the next highest bidder. And it said that it's 150% more. And it's essentially on those grounds that the NCLT has asked the COC to vote. It is also noted that Vadhavan has said that the money on DHFL's books currently will be used to pay off the retail investors, and that has found favor with the NCLT. But in conclusion, NCLT has said that COC must vote in the next 10 days. But the commercial wisdom, and in their commercial wisdom, if they still think that the plan is not acceptable, they can reject it. Mr. Chandhiok, with this background, let me come to you. Is there any basis for the NCLT to have done what it has, given that an argument is being made that this is not a Section 12A process, I've not kicked off the Section 12A process, and this is just a precursor to that?
Thank you. I must say that it has turned the table of IBC and rewritten IBC, really speaking, if you ask me. Now, if Mr. Vadhavan wants a 12-way to be invoked, whether it's a precursor or not, then according to the NCLT, 65% are people other than the banks. Let's take that position as correct for the time being. Their representative must be in COC, and if the COC is urged before NCLT that this proposal is not acceptable, I think it should have been finished the matter there and then. But in any event, the application, the two preconditions of Section 12A, even if there were no bank guarantees, I can understand, is A, the applicant who has been the applicant in filing the insolvency process must be the applicant, and it must have the strength of 95% of the creditors. I was wondering whether it is possible, maybe in a given case, that in this 65% people who were outside the COC, what the NCLT comes to the conclusion, which I think it's not correct factually, but be as it may, what prevented Mr. Vadhavan to get an no objection from this 65% people to say, we accept this proposal, and therefore the only hitch was probably the banks or anything, something like this. But how does the COC say that you will vote on this? There's not a plan. It's a settlement. The settlement has to be between two parties. And here, two parties will have to make 95% of the creditors of the company. If 35% has already rejected it, which is the bank has filed an application and filed an opposition to it, then how does it even, the prerequisites of the section of settlement is not even completed. How does the NCLT have the jurisdiction to send it back, assuming that what Mr. Vadhavan was suggesting was much more than that? And I think the second question of jurisdiction, which is also considerably disheartening to me, speaking for myself, is that on one hand, a plan passed by COC is already, judgment is reserved. It's only seeking an approval of the company NCLT or the adjudicating authority under the IBC. Have you settled that? I can understand the NCLT or the adjudicating authority has set aside that order of approval of COC on whatever ground it wanted to set aside. Remand the case back to COC and then probably send that this proposal will also be considered, something like this. Could be possible, maybe. I'm not very sure on that. A settlement prerequisites of 12A are not met in this case. And I don't think without this, the law fundamentally, I think right from Privy Council says, if a thing has to be done in a particular way, it should be done in that way, otherwise no other way. Now, I'm not looking at those fundamentals of bank guarantee, but if the 65% or 95% consent is not there, and RBI doesn't want to move that application, then probably the jurisdiction is not of NCLT, maybe somewhere else, possible. I am not refusing that part. But certainly it is not a case within the meaning of IBC to send it back to COC.
Sure. Thank you for your very candid thoughts on this, Mr. Chandhiok. For the benefit of our viewers, let's just also discuss specifically what Section 12A, which pertains to settlement proposals, says. It says that the withdrawal can only be triggered by the applicant who filed the insolvency application. 90% of COC by vote share must approve this application, and then the application goes to NCLT, and NCLT can then permit withdrawal from IBC basis such an application. Rule 30A also lays down certain measures with regards to this, which says that withdrawal can be initiated even after the COC is constituted. Applicant must state reasons justifying the withdrawal. In this case, it would have had to be RBI. And the withdrawal application must be accompanied by bank guarantee to cover IBC costs till that stage. Amir, coming here, just cut all the noise. As the first step when a promoter is approaching the lenders or creditors or the COC with a settlement proposal, in the facts and circumstances of this case, the first step is for Mr. Vadhavan to convince RBI that, look, here is my settlement proposal. Could you consider taking it to the COC? Unless that step is met, everything else just falls apart, right?
So that is actually a very good question, and it's a very tricky one because it's been answered in different ways by different benches of the tribunal. But what you are referring to is Regulation 30A. And the mechanism that is in Regulation 30A is that the applicant who initiated the proceedings, they have to come to the COC and the resolution professional, give something called a Form H, I believe, and say that now the matter has been settled. Please put up this settlement agreement before the COC and see whether they concur. The logic of that is that, of course, at the end of the day, since it's withdrawal and it's withdrawal of a bilateral proceeding, both parties have to agree. The further logic of asking the COC to ratify that agreement is that since the company is in insolvency for the benefit of all of the creditors, it's necessary to get their concurrence as to whether they are okay with the company getting out of the insolvency process. But if we take out the aspect of this being the DHFL case, and if we take out the aspect of this being the Vadhavan's case, and we look at it dispassionately, I think everybody can agree that there is a requirement of oversight. So, for example, what happens if in a genuine case or if in any other case, a settlement proposal is given to the applicant and the settlement proposal says that whatever you claim that I owe you, I am going to pay, and whatever everybody else is claimed to be owed, I will pay them. Then I think the objective behind 12A and Regulation 30A would be completely defeated if an applicant, for reasons perhaps which are not related to the debt, says that, you know what, I'm not even going to transport this proposal to the Committee of Creditors. I'm not even going to let them consider it. So what the NCLT, if at all, we have to see what the order has actually done. I would say, considering all of the, taking away all of the emotional aspect of it being such a large ticket case and DHFL and bondholders, etc., I would say that the NCLT has merely exercised its supervisory jurisdiction and reiterated that whatever has to be done in the matter has to be done with a procedure that is transparent and fair. So if there is a settlement offer and it has been given to the Committee of Creditors, and ultimately it is the Committee of Creditors that will decide upon it with 90% of its voting share, then it is one thing if the Committee of Creditors rejects the proposal. It's fair enough. Nobody can really complain about that except to the limited extent set out in the Swiss Ribbons judgment. But if it hasn't even been voted upon, then the NCLT has probably said that that is not correct procedure or that is not fair procedure. And I think if we see it from that perspective, it is a much more straightforward issue.
Mr. Chandhiok, the fact that these letters came to the COC in December 2020, and Vishy, correct me if I'm wrong, the voting happened in Jan or Feb this year, where the lenders approved Piramal's plan.
In January, yes.
January.
That in itself is a signal that COC did consider, because those letters reached the COC. Even if you take away the process part, is it the only fault that probably the creditors committee made it here is, hey, look, let's just float this letter with all the COC members and let's just vote it down and get this litigation out of the way. So is it just that process lapse that you can perhaps attribute to COC, that at least not coming out in the order that whether they actually did this or not?
No, but the question is this, that the COC is represented before the NCLT or the adjudicating authority, and the COC is represented and says, I don't accept this. That's the end of the matter. Where is the question of a procedure being followed? Procedure can't take over the substantive position. And the COC has passed a resolution plan, rightly or wrongly, which plan the adjudicating authority has reserved its judgment on.
Yeah.
It is not a case where the COC is considering the other plans, and at that stage you are saying you may also consider. It could be possible. I'm not even going, I'm agreeing with my learned friend there that fine, if the Reserve Bank, that's what I was just said, that it may be possible that if I was to go to Reserve Bank as a institution and the Reserve Bank was not accepting what I am saying, that you should place it before COC, my remedy is not NCLT, my remedy is not available to me under the IBC code. I might have to go to a writ court and ask for a mandamus saying RBI must place it before COC, or probably I don't think Section 60 will cover this up. But assuming that debate aside, that NCLT could have also asked, RBI says I don't want to do it. Therefore, he is not the NCLT or the adjudicating authority doesn't comment what is the stand of the RBI and why it doesn't want to do it. After all, there is a jurisdiction under Section 45 of the Reserve Bank of India when it has to supervise the conduct of people with respect to the funding, with respect to financial institutions. If it has to do this, then it has followed a guideline. Therefore, if the action of RBI, there's no comment, as I prima facie see, subject to correction, I don't see any comment by NCLT that the action of RBI not entertaining that application or not forwarding to the COC is mala fide or is arbitrary or is contrary to law or the settled principles of law. Nowhere. It's straight. In fact, the application is addressed to COC itself, bypassing Reserve Bank of India. So where is the question of asking Reserve Bank to look at it from that point of view? So if the precondition, this is not a case of a plan. Otherwise, 29A is becoming redundant. Otherwise, he could have filed a plan himself. And I can appreciate his coming to NCLT to say the valuations are a confidential documents, unlike prior to the amendment where they used to be made available to the people. But now it's confidential. So how it says the valuation is not correct. Now, if the valuation is not correct, then what prevents Mr. Vadhavan to ask somebody else as a resolution applicant to come and propose that if he thinks the company is to do well, which is happening in many cases. We see that on the ground, we must test this position. There are people who have put their friends, their relatives, their other people who would have come and proposed that. It doesn't need Payaswini for doing so. And then he could have said if the only ground is valuation, then I think Mr. Vadhavan would have come to NCLT to say the decision of COC is arbitrary, is not correct because the valuation of the assets of the company or the corporate debtor are much higher and it can fetch much higher and maximization of the value of the assets. Therefore, ask the resolution applicants to enhance the valuation. Could be. I'm not very sure whether this at that time, because in some cases we have seen NCLT asking two bidders or two resolution applicants to please outbid each other. And it has happened many times that we have done that. In fact, in a case, we find that this matter started with 195 crores and we ended up with 310 crores. So it's possible. Now, these are only innovative ways to see the maximization with the object of the act, with the object of the IBC to be achieved. But it certainly does not say that you go back and put that. If you have asked this resolution plan to be passed, how does the NCLT consider the plan for approval under the provisions of the IBC? Of Payaswini's approval? Two are self-contradictory to my mind.
True. Absolutely, sir. And I think you made a great point that procedural lapses cannot override substantive provisions and the substantive rights that the COC has. And the second point is, like I said, that first, I think Mr. Vadhavan had to convince the RBI to initiate this process of settlement. And eventually, Mr. Vadhavan would have to go back to the regulator to get its blessing on the fit and proper criteria. So I don't know what's his plan on this, but my colleague Vishy wants to come in here with a question. Vishy?
Yeah, please.
Yeah, thank you for that, Payaswini. The only question I had was in the judgment, of course, in the order that the NCLT has passed, they referred to this proposal that Vadhavan has made, saying that it's not a resolution plan, it's actually in the form of an OTS or a one-time settlement scheme. Now, if you look at the details of what exactly he's proposing, he's saying that I'm going to give you 9,000 crore, which is already there on the company's book upfront, and then the rest I'll pay over 7 or 8 years. I mean, does the plan really meet the one-time settlement, the definition of a settlement offer? Because it's actually most of the money that he's promising to pay back to the banks is spread out over years. Actually, there's multiple securities involved, and probably the net present value of that security over years may not be the same as it is today. So does it even meet that OTS standard?
Yes, I think you're right. Absolutely. There's a RBI's own document which says what kind of methods that you will utilize for a one-time settlement. There are guidelines laid down. If you are going under that RBI to the RBI itself, then I'm sure you have to convince them that I fall within that June notification issued by RBI. That's not the case even pleaded before the NCLT. At least I don't find from the judgment. I don't have the pleadings before me, so I will not be able to comment on it.
Sure. Amir, there's also, Mr. Vadhavan's personal guarantee issue here, right? Where I think the Union Bank of India and the consortium have said that if you really want to pay, hey, look, why don't you pay up this personal guarantee for us to even take you seriously? And I think that's 4% of COC board share that the bank has. How are you seeing that fit into this attempt to probably, let's say, intervene at this stage of the NCLT process?
So I think that is a very typical Indian businessman problem. It's a big dilemma that is faced by promoters throughout India. It appears that banks have, I wouldn't say informal, it's fairly formal at this point, but a policy that most big loans have to be backed by a personal guarantee. And considering that personal guarantees have become almost a requirement of loans above a certain size, every big loan is backed by a personal guarantee, and the promoters are relying upon the success of their business to be able to pay back the loans as and when they arise. So, in all of these cases, a promoter who is faced now with a personal liability under his guarantees finds himself in a dilemma insofar as his source of income, which was the company which is now being sold or given to another third party, that source of income having been gone, it's not really going to be possible for them to ever be able to repay the personal guarantees in full. So essentially, they are looking at their own bankruptcy situation. So definitely the threat of the personal guarantees being prosecuted is behind this attempt to settle the matter, because if the matter is settled with the banks through a 12-way or through any other OTS proposal, then the personal guarantees are also settled, which means that he is able to utilize the business and the income from the business to settle those guarantees, thereby saving him the trouble of having to dip into whatever limited or unlimited personal assets he or she may have. That is definitely a factor in these attempts to settle the matter outside the resolution plan process.
Sure, and of course, a quick mention of the Supreme Court's verdict today that has upheld the constitutionality of the notification of the government that had operationalized the IBC provisions against personal guarantors. Mr. Chandhiok, let me come to you with the final question I have. Litigation strategy-wise, what is DHFL, its COC, its advisors, and Piramal's surest way out of this mess? Should they, in the next 10 days, just convene a COC meeting, maybe given what they have done so far, just reject this plan? Or is it advisable for them to appeal this before the NCLAT? What is the best way to address this?
Look, I feel the country is passing through a very serious stretch of pandemic. We are wave 2. Litigation, of course, it's very good for all of us. On lawyers, on judges is fine. But I think a way out of making this would be, to me, it looks just to, without prejudice to their rights to challenge it or not to challenge it later on, the COC would be well advised. It's 10 days time, and 10 days time to file an appeal with the vacations going on in Delhi bench and all that. Vacation court will sit and all that. I would suggest that they can consider it on merit, and also raise that objection that we have already passed one resolution plan, and that resolution plan is awaiting approval from the adjudicating authority. We can't look at another thing, but however, without prejudice to that also, we are considering and we are either accepting it or rejecting it, both on substantive as well as on procedural aspects. I think that should be a best way out, certainly, because if ultimately I have to sell this as a going concern and resolution plan has been approved by the COC, awaiting the approval of the NCLT or adjudicating authority, time is essence in IBC proceedings. I think it will be well advised to comply with it without prejudice to their rights, and ultimately maybe file an appeal to only for this extent to say that the order is totally without jurisdiction.
All right, Mr. Chandhiok, that's sound advice, and I hope the advisors of DHFL and its QC are listening. And of course, in all of this, It's the Piramal group and its prospects to quickly take over this NBFC that's getting hurt in the process, because there are already a ton of applications against that approved resolution plan that will also, in all likelihood, all of that will get appealed. Mr. Chandhiok, Amir, thank you very much for joining us here on BloombergQuint with your views, and Rishi, thank you for bringing in your expertise and the rigor with which you've covered the case so far. And thank you so much for watching.
Thank you, everybody.